The Minnesota criminal appeals process works in that once someone is convicted, they have a certain amount of days to appeal. Now, if you're convicted of very serious offenses such as first-degree murder, it's automatically appealed, right? Specifically, and it jumps over the Court of Appeals and goes to the Minnesota Supreme Court. But a lot of other cases, you have to choose to appeal. Okay, the vast majority of appeals are handled by the Minnesota Appellate Public Defender's Office because it's very expensive to hire a private attorney to do an appeal, as we got to privately pay for all the transcripts of all the hearings, which can be very, very expensive. Whereas if you choose to do it through the Appellate Public Defender's Office and you qualify, all that stuff is free. Moreover, they're very good attorneys typically at the Appellate Public Defender's Office in that they've done this for a long time and they solely do appellate work. After, and if you choose to file an appeal within a certain predicate time frame that is required, whether it's a misdemeanor or a gross misdemeanor conviction or a felony level conviction, or if it's a probation violation, right? There's different time frames you have to abide by, and they're listed on specifically the timing, the computation of it in our Minnesota Rules of Appellate Procedure. You file your notice of appeal to let the Court of Appeals know what your issues are, and then you get a case assignment, and then you get a briefing deadline date of what your briefs are, and then you get an oral argument before the Court of Appeals. Once they issue a decision, you can either appeal the decision if you disagree with it to the Supreme Court, or you can obviously maintain and keep the decision that they make. Now, everyone has a right to appeal to the Court of Appeals, and then the Court of Appeals must hear every appeal brought before it. If you appeal a decision to the Supreme Court, they can pick and choose what cases they choose to review. So even though you may feel you were wronged or injured in some way, and maybe, or you believe that a jury's verdict was wrong or a legal decision was wrong, the Supreme Court, if you choose to appeal the Court of Appeals decision, they don't have to take your case, and then the decision is final. So they make decisions based upon, will this create precedence? Is there a confusing issue? Is it a new issue? Are there some unique facts involved? All those decisions the Supreme Court takes when it decides to make a decision at that time. So that's kind of how the process works, or that is how the process works with criminal appeals.